This is the American Law Journal.
Some lawyers are calling it the Wild West. If you're hurt by a dangerous product nowadays, the rules have just changed. Good evening. Welcome to the program. I'm Christopher Naughton. When someone is hurt or claims to be hurt by a defective or dangerous product, usually it's a jury that makes that determination. Question is, are jurors equipped to handle such complex matters? Gina Passarella with the Legal Intelligencer and ALM has this.
These three toddlers have all lost their lives after the IKEA chest fell on them. Now, IKEA is recalling 29 million of its Malm model dressers.
Wherever there are products, there will be injuries. And with injuries come product liability lawsuits.
Every day there's a new adventure. Never a dull moment in product liability world.
But who decides if a product is defective or unreasonably dangerous? Recent product litigation involves death and injury, from IKEA's chests and dressers to Volvo and Graco baby seats implicated in a child's tragic death, to a defective holster injuring a policeman for life. New case law, especially in states such as Pennsylvania, may change the way jurors see and decide these kinds of lawsuits.
I was at a conference today where someone said that in light of Tincher, that's the Pennsylvania Supreme Court on products liability, the state of the law is like the Wild Wild West.
Peter Patton is a plaintiff's attorney. The legal landscape he sees is mixed, but generally favors the injured.
There used to be a division between judge and jury, so that before a case went to the jury, the court had to make a decision that the product could be determined to be unreasonably dangerous. Now, the Tincher court has said, well, it's a jury question. And that's helpful to the plaintiffs because realistically, if you're able to say to an adjuster or defense counsel, this case is getting to the jury, the case is more likely to settle.
But are juries best able to determine what's defective or unreasonably dangerous? To compound matters, they'll have more tests to consider.
There can be two tests, the consumer expectation test and the risk utility test. And those both deal a little bit with what the consumer knows when they're getting into buying something versus what the manufacturer sort of considered while they were making the product.
Meaning juries now will more likely balance a product's possibility of causing serious harm against the cost of making that product safe. So if a new skin-detecting table saw can stop in 1/1000th of a second to save a person's finger, it doesn't mean courts will punish manufacturers for not making that safety feature available if the cost is prohibitive.
Has the jury reached a verdict?
Juries will no doubt have to decide these and other complex questions now and in the future. So don't be surprised when you see lawsuits for marijuana products or driverless cars.
So when you think about all the devastation and injury and mortality that have occurred, there's a lot more to come, unfortunately. There's a lot of people have been hurt, and the law will really continue to evolve.
The law is always attempting to balance the rights of manufacturers with consumers who claim that they were injured by a dangerous product. The question is a product unreasonably dangerous, and can a jury make that determination? As this plays out in Pennsylvania, it could have a rippling effect across the United States. For the American Law Journal, I'm Gina Passarella.
All right, three guests with me tonight. A fourth will join us in just a few moments. And later in tonight's program, we'll take a look at skin-detecting table saws. How does that relate to product liability? And also, are there marijuana and driverless cars in our product liability future? But first, Brandon Swartz joins us for the first time, a 20-plus year practitioner with extensive trial experience in personal injury and product liability matters. He hails from the law firm of Swartz, Culleton. Bill Ricci returns to the program after a 12-year hiatus with Ricci, Tyrrell, Johnson, and Gray. His name is synonymous with product liability defense. He's also a member of the Pennsylvania Defense Institute, which has weighed in on this controversy surrounding jury instructions in product liability matters. Wearing the white hat tonight is Jonathan Dreyer with Wilson Elser, Moskowitz, Edelman, and Dicker. He's been practicing product liability defense law now for over 30 years. And some of these celebrated cases that we have been seeing across the country, although a couple of them come right out of Pennsylvania as well. You know, people ask, do juries get these kind of cases? Brandon, do juries get these cases?
For sure, juries get these cases. I mean, I was saying to Bill before we came out here today, that it would take a tremendous arrogance for the plaintiff's attorney and the defense attorney to think between the two of them they could understand it. But we put 12 jurors in a box and they can't understand what the two of us could understand. So without a doubt, they definitely get these cases by the time the trial is over.
John, I got to be thinking, though, it's tough when you're facing a jury and you've got to put this into people speak. You handle a case, you're talking to your expert for 2 years, you get it, he gets it, now you've got to talk to 12 lay people.
But it's easy enough to do. The question is, I run it past people that, in my family, for example, maybe my paralegals, other people on the street, people I golf with. And the idea is just, can you explain this? Can you explain this in words that everyone will understand? Jurors are very smart, as Brandon says, but they don't speak the language that we speak. And we make a big mistake if we're assuming that they're going to understand in the terms we speak.
But Bill, I've got to think that if you had your druthers, you'd love to have these cases in federal courts and have the judge make every decision, no?
No.
Okay.
I like juries. I love jurors because a jury is an amalgam. I often analogize them to the Beatles, 4 of the greatest individual musicians, songwriters, personalities we'll ever encounter. But when the 4 of them get together, or got together for that short period of time, there was a synthesis that transcended what the individuals could do, and they get it. So jurors get it. They don't necessarily understand the same language. For example, the words strict liability have no meaning to non-lawyers because it's not supposed to, but they certainly understand whether a product is well made, does its job, and whether the people that designed it essentially put something together that was qualitative, and they get that.
But now the rules are changing. And again, it's different from state to state and federal to state courts and that sort of thing. But now juries are expected to not only know what a consumer's expectation of what a safe product would be, now you're looking at, again, a little bit of lawyer speak, risk utility, but you're really looking at other factors like how much would it cost to make this product safe? Doesn't that make your job that much harder, Brandon?
So I don't think it makes our job that much harder. Here's the reality of it. In order to have a good case, we always had to prove that a product was unsafe. So whether we were talking about consumer expectations or risk utility, what the jury really wanted to know was this product unsafe. So what we know now is, under this Tincher case that you're sort of alluding to, where we have this consumer expectation standard and this risk utility standard, we need to demonstrate to the jury that this product that we're criticizing was unsafe. And then it's our job to fit that unsafe product into the standard that the law requires. There's no circumstance where a competent attorney gets a case with an unsafe product where they can't fit it into one of those 2 tests. It just doesn't exist.
And Jerry Baldino, let's bring you into the conversation because recently you were successful. Your client, a police officer whose gun went off in the holster, was due to the fact that that holster was indeed defective. Did it make it that much more difficult for you knowing what the case law is in your state?
Well, I'll tell you, going into the case, you're dealing with a whole new body of law here. Even though the law is the same, all the cases that apply to the law were thrown out the window with the Tincher decision. So
Thank you.
It is, I know you like that, Bill. It is an unknown, but I'll tell you, going into it, I looked at the decision and I looked at the 2 theories, the consumer expectation theory and the risk utility theory. And what I did with the jury is I boiled it down for them and I said, look, this comes down to what the reasonable consumer expects. Does the product perform the way it's supposed to? And I told them that in the opening. They should consider that when assessing the holster in the Alexa case. And I told them that in the closing. And we were able to establish the holster didn't meet the expectations of the state troopers who were using it because it didn't protect the gun.
And it seems like this new case law is giving, shall I say, a little bit more deference to juries, and for plaintiffs' attorneys, that ain't a bad thing.
It without a doubt gives more deference to juries. And the truth of the matter is we get to talk a lot more during the trial than the defense is, and we get to build a rapport with the jury a lot more than the defense does. We of course believe that giving the juries more power in these cases can only be good for the plaintiff. If the jury decides they don't like our theory, that's fine. But we believe we've already gone through all of these other tests, and we're going to be able to get them to the point where they understand our theory and they agree with us that it shouldn't have happened the way that it happened.
On the defense
You know?
side, we always have to wait to go second. I always ask jurors, will you promise me to at least wait, because no matter what you hear, there is a differing point of view that we do have the right to express, but we don't have the opportunity until the time is right. What they really need to determine is whether or not the designer put out a product that was a piece of junk or a good, safe product at the time it was made. Was a 57 Chevy that couldn't pass federal muster now, which is one of the most desirable cars from a collector's standpoint, safe in the eyes, minds, hearts, and analyses of the engineers that designed it? There's only one theory. The theory is, was the product unreasonably dangerous?
Bill, I appreciate the fact that you're a steadfast defender of these vehicles, and admittedly, you know more about these cars than anybody I've ever met. However, what you have to admit is, if the law didn't allow plaintiffs to criticize a 57 Chevy for not incorporating technology as it would be developed, we'd still be driving in these 57 Chevys that we don't have today.
Well,
so it's necessarily true that we have to be able to criticize these products. We have to be able to hold the manufacturer to having the state-of-the-art technology. And there was a day, I don't know if it was in 58 or 59 or 60, where that car necessarily was not safe anymore, as you've described, and we have to be able to criticize the manufacturer for that.
I like the fact you used the word, Brandon, state-of-the-art. I really like that. And as clients and manufacturers will admit, if they're good ones, we're always trying to make a better product. We're always trying to improve it. Otherwise, stop doing what you're doing.
Bill, let's be real about this. It's not a sense of criticizing the 57 Chevy. But for instance, right now, every single car that we have has anti-lock brakes.
Correct.
The 57 Chevy did not have anti-lock brakes. Yet
Correct.
the anti-lock brakes were patented in the 30s. So it took 40 years before any manufacturer was willing to take something that was patented on the market before they even put it in the vehicles.
And yet in the Packard decision, I think it was the Fifth Circuit, sometime in the 80s, or no, late 70s or 80s, a manufacturer was sued for including them, much like the original manufacturers of cars in the late 80s and early 90s when they were phasing in airbags. They were said, well, you didn't have an airbag, and now later on people were saying, well, you have an airbag, and as a result somebody got killed. So it's all relative, progressive, analytical, and it can't be separated from the context.
Let me throw this out to the panel, because it seems like we're starting to see an element that we didn't see in product liability cases many years ago, and that was the notion of cost. Now, Brandon, years ago, especially in Pennsylvania, before this risk utility issue came in, at least the black letter of the law said you don't look at cost. Today, you have to look at cost. You can't take a product liability case to trial without looking at that.
So that argument, we're putting before the jury a decision to make. How are we going to make the company go out of business? Are we going to allow them to make X amount of profits? Or are we going to reduce the amount of profits they have to make as a trade-off for safety? But yet, the analysis now coming in, and the jury's factoring in, are we going to allow this defendant to make a buck, essentially? And are we going to offset that with the risk that's involved?
I would almost suggest that cost is perhaps the third factor in with risk and benefit. It's not really spoken in terms of that analysis.
I think that is actually
Was
a
it
fair
always there,
statement.
John? Even though it was never spoken, wasn't it always there?
I think it was always there, and I think if you want to make it presentable to a jury, you have to talk about it in terms of consumer cost. In other words, what does the product have to sell for, and what is the consumer going to have to pay for it in order to get it with these features, as opposed to what is the defendant going to have to pay to put that feature in.
And John's right in this respect.
I don't know that the analysis is really right in the jury's face. What is it going to cost the consumer? How's that cost going to be passed down? But I think the juries are going to consider that. They're going to consider what's the cost to make this product better and what's going to trickle down to me.
And Jerry, did that come up in your case, the Alexa case?
It did come up in my case, but it wasn't a central issue because my case was a bit unique in that the product manufacturer made a safer holster of the same type, a different style that would accommodate the gun that was used, and other manufacturers made it, and it was pretty much agreed that there was no real cost difference in these holsters. I think the jurors are going to consider that. They're going to consider the cost to the manufacturer, they're going to consider the cost to them, they're going to consider the cost to society, but ultimately the purpose of strict product liability law is to ensure that product manufacturers manufacture a product that contains every element necessary to make it safe for its intended use.
Strict liability is a meaningless concept other than to lawyers. What product liability does, it simply allows the plaintiff not to have to prove negligence. But there's always that gnawing concept that the jury wants to embrace. Whose fault is this?
That's why Jerry Baldino at one point in time called this the Wild, Wild West. Coming up, how do recalls affect product liability matters? And are there product liability matters in our future regarding marijuana and driverless cars? We'll be back in a minute.
This week's American Law Journal is made possible in part by Law Catalyst, video and film production for the legal profession. Go to lawcatalyst.com. Beatty, Sloan, and DeGenova, providing consumer protection in injury matters for over 30 years. Blank Rome, providing strategic advice for employers in today's workplace. King Spry, serving its Pennsylvania clients in family law, business, personal injury, and school law for over 30 years. And The Legal Intelligencer, an American lawyer media publication and the oldest law journal in the United States.
Every day in America, 12 people lose their fingers using band and table saws, but with emerging skin-detecting table saws, is the cost worth preventing the risk? Let's take a look.
Here is a good rule of thumb, or potential lack thereof. Table saws can bite. The blade has a sensor that detects electrical conductivity. A piece of wood is not very conductive, so the saw goes right through it. A salty, wet finger is conductive.
And so I'll hold it just like it was my thumb.
You gotta be kidding me.
Let's see it.
There's nothing.
There it is.
That is amazing. That really, I mean, that's, it's like nothing ever happened.
So fascinating, and again, we're just on the precipice of a great technological age where people can actually, prevent losing their fingers. Our producer's grandfather lost 6 fingers over a period of 10 years back in the 1940s, back when we didn't protect workers' rights. Let's hope we're not going back to that. But question, I mean, Brandon, you've handled these kinds of cases before. You don't handle these kind of cases if this kind of manufacturing, this kind of technology is available.
So here's the way we look at it, Chris. Every single day, I make my first mistake before 10 a.m. It never fails. I'll make my first mistake before 10 a.m. So let's assume that I'm typing something on my typewriter when I make my first mistake. What I do is I hit delete and I go back and I type it again and I move on to the next thing. We cannot have a circumstance where if somebody makes their first mistake of the day, the consequences are so severe that they lose their finger if the technology is out there to prevent this from happening. So we need to build it into the technology and make sure that it is available to every single person that is using this technology. Chris, I often tell the story that I'll have somebody call from one of these small towns in Pennsylvania, and they'll tell me I was working on X, Y, or Z saw machine and I lost a finger. And then I go to meet with them and I find out they're not even the only person in their family that this has happened to. So this technology is out there and we need to implement it to make sure that this doesn't happen.
But Bill Ricci, at what cost?
Well, I think, again, Chris, cost is...
Because these are very expensive machines, and as you saw in the demo, once a finger goes there, it saves the finger, kills the machine.
If we can get to a point, and I think most of the manufacturers that I've had the privilege of representing are always trying to get to the point where they can eliminate all kinds of reasonable problems that'll happen. They're always pushing that envelope to make it better, to make the next level of protection. That's part of their goal that's so integral to a good design that it's never a separate consideration. I don't think you can parse things like cost, the number of incidents, all those things from the overall consideration. What are they trying to accomplish when they're constantly improving a product and developing a design with integrity.
Well,
But
Bill,
Jerry,
Bill,
but-
you
go
keep,
ahead, Jerry.
Bill, you keep saying that, and you mentioned earlier that responsible manufacturers want to develop better products. And I'm sure there are manufacturers that want to stay on the cutting edge and want to develop safer products. But the fact of the matter is, I read about this technology for saws years ago, and I had to go research it and dig through and finally find the guy who invented the technology, and my firm has spoken with him about cases. And the fact of the matter is, you go into any Home Depot, Lowe's, it's not there. So why isn't it there? It's there because there's a cost, and it's there because manufacturers and the industries fight innovation that's going to increase their costs.
But Jerry, as plaintiff's counsel, you would probably admit, look, if the machine was, I'm going to pull an outrageous number, is $1 million, you understand that, you know, that can't be rolled out no matter how safe it is.
Sure, that's always a consideration. It's always a consideration. But this is the same thing the manufacturers did when they came out with airbags. When any new innovation, they yell and scream, it's going to cost money, it's going to drive up the costs, it's going to put us out of business.
Actually, that's a great example, Jerry, because when manufacturers were first talking about airbags, and there was increasing pressure, as it were, including political pressure on the big three to implement them, there were engineers that said, wait a minute, we have to push back a little bit because you are now adding energy to a crash. And energy is that which causes injury. So therefore you need to manage this. You can't just willy-nilly apply it. There may be things out there that we haven't thought of. And now, 20, 25 years later, all of the cases are about energy that's been added by an airbag that's caused an injury that but for the airbag deploying or deploying in an improper manner wouldn't have existed. So it's complex and it's evolutionary by definition. I don't think there's anybody out there that doesn't say you should take a serious look at something like a skin detecting system on a saw. It's a great
It may
innovation.
in fact be evolutionary, but it's not totally evolutionary and it's not totally organic. The issue needs to be pushed because if the issue is not pressed by juries holding the manufacturers to this issue, there will be no evolution. We would still be in the dark ages and it won't evolve. Bill, you know full well that when they made washing machines in the 50s, only women were using the washing machines, no men. None of us in the 50s had grandfathers that were doing the wash. It just didn't exist. And what would happen is these machines were going on the spin cycle, the women would reach their arm in, and the arm would get ripped off when it got caught in one of the pieces of clothing. And what they would say is when they would bring a product liability case, they would say, we put a big warning on there. It told you not to reach your arm in. But then somebody developed a technology that when you opened the lid, it stopped spinning. And the first time that technology came out, it was expensive. And it made a $100 washing machine $120. And it added 20% to the cost. But there's no circumstance where we didn't need to evolve to that immediately. Immediately we need to evolve to that. So while I agree with you that eventually the evolution would occur just because of profits, we need to push the issue and speed up the process of evolution by holding the manufacturers to these standards.
Push the issue, but cost is still a factor, and more so across the country because, again, they're going with this risk utility standard. Let's talk a little bit about recalls because, again, the IKEA case, which came out of the genesis of the case coming out of Pennsylvania, 29 million dressers and chests have been recalled. What impact does a recall have on a product liability case? I know it's not going to exonerate your client. It's not going to sink him either.
Well, I would first add that I would never counsel a client not to go forward with a recall.
Agree.
For reasons of avoiding lawsuits, because you're going to wind up with more lawsuits and they're going to be worse lawsuits. But I don't know that it really increases your liability. I mean, it's the injuries that drive the lawsuits, not necessarily the fact that the product has been recalled. If there's something wrong with the product and injuries are resulting from it, I think you're going to get the lawsuits anyway, and I think you have to recall it if you understand that that's happening.
And Bill, if I understand in the IKEA matter, they actually were taking some remedial efforts. I think they were selling braces to, in the meantime, to brace these chests and these dressers up against walls.
Yeah, that's my understanding, Chris. And you know, I learned a long time ago from someone that was a very good engineer, and he was also an attorney. He said, all of us attorneys, we want to believe that we make the world better and safer, and I believe we do, and I think we all have that consensus. But let me tell you this, he said, Listen to your engineers. If they think it's a good idea to make a product better, do it. If it means recalling it, if it means fixing it, if it means changing it, do it.
Let's take a peer into the future. So wherever there are going to be products, we're going to have an agreement. There's going to be liability. There's going to be litigation. 2 on our radar screen. Another 8 states have said that marijuana is a legal drug. Is there a marijuana product liability case in our future, Brandon Swartz?
There's without a doubt in our future. The truth of the matter is that we have to see how these products develop. We have to see how it's being used. But I can definitely envision a scenario, for instance, where a child gets a hold of the neighbor's marijuana that they kept out there, and the neighbor doesn't have adequate insurance out there, and somebody goes after the manufacturer of the marijuana for not having it locked away or something along those lines. But there's going to be consequences to the marijuana, and there will be litigation that develops at some point.
I think you're going to see a lot of warnings type claims. I think it'll be treated to some degree much like alcohol.
Right. Well, let's look at a subsegment of the marijuana. Let's look at all the candy bars, the lollipops, the chewing gum, the
malt balls,
all malt balls. I mean, if that's not a products liability issue for the industry, I don't know what is.
Probably already is in Colorado, Jared.
Yeah,
right.
Yeah, and I don't get it. I don't understand. If you want to get high, do you really need to eat a candy bar to get high? If you want to get high, take a pill or smoke it, whatever you're going to do.
That's a great question, and I think there's a lot of validity to that. That's going to have to be evaluated. And on the flip side of it, what's been an issue, at least in some of my cases, is with alcohol, there is a booze baseline. It's defined now. Is there a baseline, for example? What is the synergistic effect, for example, of a joint and a couple beers? What effect does that have? What's its admissibility going to be? How are you going to factor that in? How are you going to test it? Are you going to ingest it and get cancer? I mean, all of these questions. And then you talk about driverless cars. There is a manufacturer that did a prototype. It's a foreign European manufacturer, did a prototype of a driverless car with a dog driving it. So why not have a beer in the car or a joint?
I would go so far as to say with the driverless cars, I can virtually guarantee you that they already have actuarial models where they've built the lawsuits into the cost of the case.
How could they not? I want to thank my guests for joining me tonight for a very spirited discussion. Now, has anyone figured out, other than the fact that you're all good looking, what the common thread is with all 4 of my guests tonight? Can anybody figure out what that is? Going once, twice. All 4 of you graduated from Temple Law School. All 4 of you. So there must have been something in the water, Bill, even many years ago when you were attending
I know the answer,
Temple.
Chris. No, none of us voted for Nixon. Nobody did. He won by a landslide, but nobody I've ever met voted for Nixon.
I was too young. So.
All right, Jared. Well, thank you. Jerry Baldino, thank you for joining us tonight from Sacchetta and Baldino, right outside of Philadelphia. Brandon Swartz with Swartz Culleton, plaintiff's attorney, over 20 years in practice. Bill Ricci, who has been joining us, who joined us many years ago, has returned to the set to discuss product liability and bring his many years of experience. And Jonathan Dreyer from Wilson Elser, thanks for joining us tonight. For all of us here at ALJ, thanks for joining us this week. Until next Monday night, case closed.